Good morning. My name is John Zogby. May it please the Court. I represent the appellants in this matter, Metropolitan Antiques. This is an appeal of a granting of summary judgment by the trial court, which ruled that there was no insurance coverage for the plaintiff's claims in the underlying case. The underlying case is a class action matter brought by a number of Massachusetts residents against Metropolitan Antiques, which is a small New Jersey antiques dealership. The basis of the underlying case is that Metropolitan allegedly sent a number of junk faxes or faxes under the unsolicited fax advertisements under the Telephone Consumer Protection Act, TCPA, from the years 2001 to 2003. Basically, what the TCPA prohibits is the transmission of unsolicited fax advertisements without the prior consent of the recipient. Now, there are two types of claims in the underlying case. One under the property damage for the loss of the ink, toner, and paper consumed by the faxes, and also an advertising injury, the claim of invasion of privacy. I'm going to focus my short amount of time on the property damage issue. The trial court ruled that basically I want to start out by saying both New Jersey and Massachusetts law are, there's no discernible difference between Massachusetts and New Jersey law on these issues. And so what the trial court was an error when it granted summary judgment, because what it said was that in defining whether or not these transmissions was an accident and thereby covered by the policies, or whether there was an intentional act by the sender, by Metropolitan, that the actual transmission of the fax was the determinative issue as to whether there was an intentional act or not. However, under the TCPA, the only violation of the TCPA is for unsolicited faxes. So therefore, if there's not an unsolicited fax, there's no harm. Not every fax transmission results in damages, results in the loss of ink, toner, and paper. It's only the unsolicited nature of the fax which results in the claim under the TCPA. Therefore, the correct question, the question to be answered is whether or not my client or any sender of a fax under TCPA intended to send an unsolicited fax. Now, both New Jersey and Massachusetts law use the same criteria in determining whether or not an act for insurance coverage purposes is intentional or an accident. The courts don't look at whether there was an intention to actually commit the act. They look at whether there was an intent to commit the harm complained of. Under the Voorhees case, the New Jersey Supreme Court, under the Abernathy case, the analysis is whether there's an intent to commit harm.
Well, in this case, how did the policy define occurrence?
The policy defines occurrence as an accident.
So
the term accident is not defined by the policy. That's why we look to the interpretation of the word accident in terms of insurance coverage under the rulings of both this court and the New Jersey Supreme Court. Both courts state that the analysis is to look not at whether there was an actual intent to commit the act. So in the Abernathy case, the intent to throw a rock. The issue is whether there was an intent to cause harm by throwing the rock. Here, the question is not whether the sender intended to press the fax button, the send button, but whether he reasonably believed that there was permission or otherwise had an intent to send an unsolicited fax.
Well, the trial judge said, New Jersey law places emphasis on the accidental nature of the resulting injury rather than the act that caused the injury, and cited to SL Industry versus American Motors.
That's true, and I think that is the correct analysis. And when you apply that analysis to the facts of this case, what you see is that
You intended to send a fax. You didn't intend to send an unsolicited fax.
That's right.
So it was an accident to send it to the wrong person. In essence.
Well, for coverage purposes, yes. We're looking at coverage here, and we're looking at the plaintiff's complaint is that there was negligently sent faxes. In both New Jersey and Massachusetts law, the courts match the complaint to the reasonable plain meaning or plain reading of the coverage. Here, there's a complaint that the complaint says that there was the unintentional sending of the faxes. So even if my client or any sender of fax was under was under even a mistaken belief that they had permission to send the fax, okay, that's negligence. That's even recklessness.
So if I deliver a package to the wrong customer, and the customer has to open it and send it back, that would be an accident?
Yes, that would be unintentional.
Unintended accident causing harm, the cost of opening the package and sending it back. That would be the
Right. In that analysis, in that example, it's not the actual intent to deliver the package that's the determinative factor as to whether or not there's coverage. It's the intent to send a package to the right person. Here, even if my client, he hired a third-party marketer to send out these faxes. This person was specialized in marketing. My client's expertise was in antique services.
Mr. Zogby, I know it's left, but you did select 5 minutes, and you've now had almost 6.5,
Okay.
7.
Thank you.
I think we understood your argument.
Thank you.
Okay? Mr. McHugh?
May it please the Court, Your Honors. My name is Matthew McHugh, and along with Ted Broderick, who's at counsel table, we represent the consumers in the underlying consumer class action that's brought pursuant to the Telephone Consumer Protection Act. And just to follow up on Attorney Zogby's comments, I think what's important to focus on the property damage side of this policy, it's not just the four corners of the complaint. Of course, you look to that. But the undisputed evidence before the Court is that Metropolitan Antiques was misled by a third-party marketing outfit called Village Fax, who misled it into thinking that marketing via fax was appropriate. They did rely upon them. They had no idea who they were sending these faxes to. That is essential analysis as to the occurrence, the accident side of the policy. I'd like to focus my comments on the advertising injury side of the policy, but I would like to point out to the Court a very important point, that the occurrence requirement only applies to the property damage coverage A side of this insurance policy. There is no similar occurrence limitation to the advertising injury side of the policy. Judge Van Gestel in his decision suggested that there was, and that, I suggest, was clear error. Another very important point I'd like to point out to the Court is that since we did the briefing on this file, there has been very important case law that has come out primarily from the Illinois Supreme Court. Judge Van Gestel issued his decision without the guidance of the Illinois Supreme Court in a case called Valley Forge versus Swiderski.
Did you send us a letter?
We did,
Yes.
Your Honor.
Okay,
And we can
because I
certainly
don't
do
have
that
it.
again. But
No, it's
the
fine.
reason
It'll
why
be
that
fine.
case is so important, and I would suggest to you, Your Honors, that if there's one case to look at, that is the case, because it's comprehensive. It looks at the issues from both sides. It cites all the case law on this issue. The reason why that case is so important is because Judge Van Gestel relied almost entirely on a decision called American States out of the Seventh Circuit Court of Appeals.
Yeah, that's the Easterbrook opinion.
Exactly. And Justice Easterbrook in the Seventh Circuit was trying to divine how Illinois would rule on this exact issue. Exact policy language, exact context of an underlying class action. And the Seventh Circuit...
But now the Illinois Supreme Court has said the Seventh Circuit decided it incorrectly. This is how we decided under our state law.
Thank you, Your Honor. Thank you.
Very irritating.
But the
to be a
circuits are
federal
split,
judge.
aren't they? I mean, they
Well,
go, you've got the Fifth Circuit, the Seventh, the Eighth, the 10th, the 11th, and the 4th. And
Well, the vast majority go in favor of coverage. The only two circuit courts of appeals finding no coverage was the Seventh Circuit, which essentially now has been reversed by the Illinois Supreme Court, and the Fourth Circuit in resource bank shares. Now, that leads me to another very important distinction. The advertising injury language in this policy requires only three things: an advertisement, the publication of material that violates the right of privacy. Three things. In resource bank shares, the Fourth Circuit, and the only other appellate court case going against coverage, which is ACS from California, a mid-level appellate court, the language in those policies was materially different. It read, making known to any person material that violates a person's right of privacy.
May I ask how
Yes, sir.
you define privacy?
Well, that's an excellent point. It's not defined in the policy. So under this court's teachings for many, many years, you look to the lay definition, the common understanding of the word privacy. The word privacy is commonly known as the right to be left alone. That's how we define it. That's how many courts have defined it. The courts that have gone against coverage take the word privacy that's undefined in the policies that the insurance industry drafted. These are form commercial general liability policies. They didn't define it. They take that word and they split it into two things: privacy interests relating to secrecy and privacy interests relating to seclusion. And what the court says, and this is American states, this is really the teachings of American states, they look at the policy and they say, we think that the privacy really relates only to secrecy interests, whereas the TCPA really protects seclusion interests. Therefore, the type of privacy we think they intended is not covered.
What was the reason for making that division in the definition?
You'd have to get into the mind of Justice Easterbrook, but essentially he looked at the term privacy, and from our perspective, a fundamental error that you don't take words that appear undefined in policies and
Well, he wasn't looking at an insurance policy. First thing, he's looking at a federal statute.
well, he was looking at the word privacy as
No,
it
I
appears.
understand that.
Right.
So he's not construing anything. I mean, he's trying to figure out what the federal government was doing, correct?
Well, the federal, I submit to you, it's really not disputed that the TCPA protects privacy rights, and even Justice Easterbrook in American states conceded
No, I understand that. But
Right.
what he's trying to figure out is what does that mean within a statute, correct?
Well, within the statute, but really more within the policy, Your Honor, I would submit. And he's looking at the policy, and what he's doing that's inappropriate is that he's adding legal restrictions to the word privacy, and when he interprets the simple phrases, publication, material that violates right of privacy, he's adding language into that language. And Justice Van
Wouldn't it
Gessler,
be a simpler answer from your point of view just to say, accepting the Easterbrook analysis, that this policy is ambiguous and therefore the insured gets the benefit of that bargain?
exactly, Your Honor.
I
And,
mean,
and I would
if
submit,
privacy means all these different things and the insurance company didn't have the good sense enough to define it, he gets covered.
that's exactly right, Your Honor. And I would submit to you, at the end of the day, when we hear from my brothers, when we hear from the insurance industry, we have amicus briefs from most of the insurance industry, on their best day, that's what their argument is. They're going to be saying to you that publication really means publication to a third party, and material really means, well, content and material, and privacy really means this but not that. On their best day, what they're talking about is a secondary rational interpretation of this policy language. And as this Court has said over and over again, Justice Cordy, Justice Ireland, in fairly recent decisions, that where there are two rational interpretations, you take the interpretation that favors coverage. Where there's an ambiguity, we're not just saying we disagree about coverage. An ambiguity is defined as, do rational people disagree as to how this language should be interpreted? And I submit to you, when you look at the circuit courts of appeals that go different ways, yeah, on their best day, what we're talking about is an ambiguity. What we're talking about is another rational way to look at this. And given those facts, there must be a finding of coverage under those circumstances.
If we decide that it's ambiguous and this advertising injury provision applies, do we have to decide the accident issue?
Well, I would submit to you that it would be helpful if you decide. Of course, you don't have to. But the way the policies read is that there's different coverage limitations for property damage versus advertising injury, or arguably different coverage limitations. So certainly a direction from this Court as to does property damage apply would also be helpful.
Okay.
Unless the Court has other questions, I'll rely on the briefs.
Well, I mean, if you look at the coverage language, the injury they're talking about here is, let's see, personal advertising injury means injury including bodily injury arising out of the oral or written publication of material that violates a person's right of privacy. I mean, ordinarily, reading that, would you really think of sending a fax to someone as an oral or written publication of material that violates a person's right of privacy? I mean,
Well-
don't you really focus on what is it that's being published and the content of what is published as being the thing that needs to violate a person?
Well, Your Honor, that's certainly one of the arguments that the American states focused on, and my response to that would be that the argument is that it's got to be the content of the facts, not just the facts itself, that violates the right of privacy. In other words, the substance of the material. And I would submit to you that even if you do look at things that way, instead of just saying it's the publication of material, obviously sending thousands and thousands of faxes is a publication. A junk fax is material. These terms are undefined. And does it violate a person's right of privacy? Well, it certainly violates the TCPA, which is a federal statute that protects privacy interests. But if you require a content requisite, which is not in the policy, but even if you do require that, we still prevail because it is content that matters. And that's a fundamental flaw in American states and a fundamental flaw in my
I have to say, Mr. McHugh, you lost me there.
Okay, let me back up, Your Honor.
No. Why the content makes
Because
any
the
difference?
content matters, because just sending an unsolicited fax doesn't violate the TCPA. It's sending an unsolicited advertisement. So
Oh, I
when-
see. I'm sorry.
when a
thought-
consumer
I'm
gets-
sorry.
Okay, Your Honor. But when a consumer gets a fax...
No, I'm with you. I thought you meant the form of the advertisement. So,
Okay. But to respond to Justice Cordy's question, to determine if a TCPA has been violated, a consumer has to look at the fax and think to themselves, is this solicited or unsolicited? Did I ask for this or not? And most importantly, is it an advertisement? Does the content of the fax rise to the level of an advertisement? Is it a political announcement? That's not covered. Is it an announcement about a free concert? Perhaps that's not an advertisement.
No, that is an advertisement, I can assure you.
Okay. The faxes in this case are
But
unquestioned
if they're just
advertisements.
lots of faxes saying, I don't agree with your decision, I don't think that's an advertisement.
Okay. If there's other questions from the bench, I'm happy to answer them.
Thank you, Mr. McHugh.
Thank you very much.
Mr. Gusefa?
Thank you, Your Honor. May it please the Court, John Graceffa here for the Terra Insurance Company. Along with me, Fei Chen. Mr. Aylward represents the interests of the Royal and SunAlliance Company. The Terra Insurance Company and the Royal SunAlliance Company share a common brief and a common argument under coverage A and coverage B. I will mention coverage A and argue that portion of it. Mr. Aylward will handle the second portion of it. Two unique points to Terra Nova are that our policy contained a penal statute exclusion under coverage B, as well as a punitive damages endorsement of the entire policy.
Well, there's no punitive damages being sought here, right?
Our argument, Your Honor, that by the very nature of this statute, it's a punitive statute
Okay, I see what you mean.
and a penal statute. One's an exclusion, the other one's an endorsement. I don't think there was any confusion in Judge Van Gestel's decision about occurrence. I don't think he utilized the occurrence analysis in Mr. Aylward's portion of the argument, and I'll let him handle that. However, under coverage A, which is the strict property damage portion of this, there needs to be an occurrence. This Court and the Appeals Court have held many times that an occurrence means an accident. It is defined as an accident in the policy. This insured went to a blast fax service and asked them to send out tens of thousands of faxes to customers all over the Commonwealth of Massachusetts. As the amicus brief said very well, and I think our brief said very well, and Van Gestel said, it is a natural and probable consequence of sending out hundreds of thousands of faxes that somebody's going to get it, it's going to be unsolicited, and that is the very nature of their complaint. And the very nature of a TCPA violation is the receipt of an unsolicited fax. The insured here intended the natural and probable consequences of the property damage. It is known in the business community, it is known in the community that if you send a fax out, and moreover, if you send out hundreds of thousands of them, you're going to use up fax machine time, toner, and et cetera. To argue that you need to intend a violation of the statute
We negligently did it. You'll notice there's an amended complaint in here. The first complaint in the class action alleged that these were sent out intentionally. When the declaratory judgment action was filed, all of a sudden, in the underlying case, we received an amended complaint in which the 4 counts were changed to negligently sending out a fax. I fail to see the common sense that behind an argument that you can send out this amount of faxes in some kind of negligent way. Metropolitan and/or its fax agent didn't accidentally push a button or a series of buttons and send out all these faxes. It was part of a advertising campaign for Chippendale chairs and other things, and all of these people all over the Commonwealth, through their fax machines, received these things in an unsolicited way, purposefully, and the injury was absolutely obvious and should have been obvious to them.
Was there any suggestion on the record before Judge Van Gestel that one could send out, is it thousands or hundreds of thousands of faxes to a population of people that had agreed to receive such faxes about antiques?
That was never raised below, Your Honor, and it was never argued.
So that if, for example, the assumption is you go to a third party and the third party is going to take the membership list of the Society for New England Antiquities, those people haven't agreed to receive advertisements from Metropolitan, correct?
If they so agreed.
No, that they haven't. There's nothing to say they had agreed to do that.
They didn't agree, Your Honor. None of the recipients of these faxes, to the best of my knowledge, even knew they were coming.
No, I was trying to ascertain whether or not there's even a basis for saying this was negligent, because unless you are purchasing a list of recipients who have affirmatively agreed to receive advertisements by facsimile, you are necessarily violating the federal statute, correct?
That's a very good point, Your Honor. I think that's exactly what happened here. I think
How did they determine who they went to?
Your Honor, I don't know.
I
think the answer to that question, Your Honor, is that the fax service went through the telephone books or the Internet and came up with a number.
Why do I still keep getting unsolicited faxes if it's...
I wondered that myself, Your Honor, and...
No, not from these clients, but I mean, I thought the federal government had...
They went through the telephone book and what?
And the Internet, Justice Greene, I think
For what?
Well, I think Metropolitan probably said to itself,
but
Paul Saperstein and other auctioneers, counsel, accountants, and these particular
That's why I
groups.
asked.
So they had a plan.
They did have a plan. They had a precise plan. And they
Not to send it to everybody, but to try and find people that might be interested in this service.
Correct.
But am I correct that every sending of a facsimile to a person, a fax number, which has not been solicited and is advertisement violates the federal statute?
It's my understanding of the federal statute that if you send a unsolicited fax to a recipient who doesn't know it's coming, then at least according to my brother's arguments below, that is a violation of the TCPA.
Even if the recipient may have an interest in the subject matter of the fax?
I believe the way the statute is written, Your Honor, it just says unsolicited.
Just plain says unsolicited.
Yeah, you can still use the mail, but...
The term unsolicited advertisement means any material advertising, et cetera, without the
That you
person's
didn't
prior
ask for.
express invitation.
Yeah, okay.
But we're all getting unsolicited faxes at home that contain advertisements.
I think, Your Honor, the industry, the fax industry, has found clever ways around the TCPA. I just want to take one moment to add
This
that
lawsuit may put an end to that.
we believe, at least from the Terra Nova perspective, that both on coverage A and coverage B, that the punitive damage endorsement of the policy eliminates
Wipes them out.
coverage. Yeah. And I would turn it over to my brother right now.
Thank you, Mr.
Thank you.
Elwood.
Madam Justice, may it please the Court. To follow up on the last question, there is an exception in the TCPA statute if there was a prior business relationship. Otherwise, it's merely the issuance of an unsolicited fax that creates liability. Let me pick up briefly on two of the comments that my brother, Mr. McHugh.
To whom do I complain? to the FBI?
The
Well,
federal,
supposedly
actually,
you call the number on the fax and you say, don't send them
No,
anymore.
but that's,
and it-
Doesn't
But that
work.
doesn't work.
and they're never there, Justice Grady. They are never
Particularly
there.
as to people selling these stocks.
You'll find these people in Costa Rica. You complain to the Federal Communications Commission for whatever good it is. Let me start at the end of my argument, which is that the plaintiff trial lawyers who have filed an amicus brief in this case have argued that it is essential in order to further the public policy of Congress, which is to deter abusive telemarketing, that there be insurance coverage. Let me suggest that the way to stop the faxes that we get at home is for these verdicts to be borne by the people who telemarketed abusively. Creating insurance coverage for these kind of claims is only going to perpetuate the litigation and the abusive telemarketing
Well, that's a good
practices.
policy argument for the legislature or somebody to address. How does the terms of the policy
Let me,
not apply here? We've already heard about the accident
for two
thing.
specific reasons, Justice Greene. First, the coverage is not for invasion of privacy. Coverage B is a newer and different form of coverage than what Mr. Graceffa was talking about. There isn't coverage for any kind of bodily injury or property damage, which is what coverage A is all about.
Right.
Coverage B is specific to certain enumerated torts, like false imprisonment, or in this case, oral or written publication of material that invades a person's right of privacy. Note that the coverage isn't just for invasion of privacy. It isn't just for publications that invade privacy. It's for the oral or written publication of material. And that constellation of the publication of material that invades privacy pervades the privacy jurisprudence back to Brandeis and Warren's.
May I just ask you how you define privacy?
I think,
you're saying you don't
This-
have to because there's no material.
well, you don't, because our courts have consistently interpreted this coverage as being coextensive with the common law, or in this case, the statutory meaning of those torts. So if you look at cases like KMS Patriots or Smart Foods or the First Circuit's opinion in open software, where we're looking at things like unfair competition or disparagement, the scope of the coverage is coextensive with the tort. Now, there are admittedly different kinds of privacy, but what Judge Easterbrook was talking about in the Seventh Circuit and the other courts that have adopted our analysis is that the publication of material that invades the right of privacy is secrecy. And that makes sense. If you look at Brandeis's article in 1890, what he's worried about is material that invades a person's right of privacy. It's not the fact of the fact itself that somehow invaded privacy. And it's not that Congress, in enacting the TCPA, could be concerned with the content of the facts.
Yeah, and the placement of the advertising injury provision with those other provisions sort of defines it, because the other provisions deal with the type of privacy invasions that you're talking about.
Exactly. And they are concerned with the argument that the
So
insured...
there really is no ambiguity. I mean, it'd have to be two really equally rational interpretations, and here you say there isn't.
In order to find ambiguity here, you have to atomize the terms of the policy, look at them each in isolation according to dictionary definitions, and then cobble them back together.
Mr. Aylward, as you know from my earlier question, I haven't read the Illinois Supreme Court decision. Have you read it?
I have, Your Honor.
And is it consistent? I take it it's inconsistent with your position.
Well, obviously it is, Your Honor. But it's also inconsistent with both the law of Massachusetts and New Jersey, in which we don't discern any difference between those two states' canons of law. But it goes off track in two respects. It ignores the requirement of publication. It essentially says that why should we divine different types of privacy interests? TCPA is a privacy statute. There was a publication in the sense of the dissemination of faxes, therefore there's coverage. Our state insurance jurisprudence requires that you look at policy wordings in context, and also that each word in an insurance policy be given meaning. The Swiderski case in the Illinois Supreme Court ignores publication, and it takes it out of context. It doesn't look to the other offenses in the advertising and personal injury definition right around it, like utterances that defame or libel. And it doesn't make sense. The coverage is for an oral or written publication of material. If material is defined as the physical thing, the one-page fax, how do you orally publish something physical?
Well, the defendant's argument says, privacy, we keep expanding what we mean by privacy, and they say, the federal government has concluded that as long as it's advertising and unsolicited, that's an invasion of privacy. And you're essentially saying, well, that somehow isn't covered when the policy.
I would respond to that in two ways, Madam Chief Justice. First, there are different kinds of privacy. There's only meant to be coverage for this specific type of privacy. Second, as our courts have repeatedly recognized, coverage B is coextensive with the offense, the tort, that's claimed. Now, in Massachusetts, which would be the governing law as far as liability, it's General Laws, Chapter 214, Section 1B.
Yeah.
And as recently as last year in the Nelson versus Salem State College, this court reaffirmed that there's a requirement that there be an unreasonable, substantial, or serious interference with privacy. And citing to the Schlesinger case, this court went on to find the plaintiff must show that there was a gathering and dissemination of information which was private. In this case, nothing that Metro Antiques did in sending out an ad about an estate auction involving Chippendale chairs gathered or disseminated private information about Mr. Fray-Witzer. That is the kind of argument that the Illinois Supreme Court didn't go near. It may not be the law of Illinois for all I know. And admittedly, the circuits are split on this issue, but I don't think this court determines issues like this based on a scorecard. That would be like the Red Sox winning because we had more hits than the other side.
My concern
That
is
would be good.
It'd be nice.
My concern is only, and whether, I don't think we look at what the contemplation, maybe you look at the contemplation of the parties, but it might be that there has been promulgated a statute that says you do this, that's an invasion of a right of privacy. Your policy happens to say violates a person's right of privacy. What is protected under the federal statute is a person, and what is protected is a person's right of privacy. And it seems to me that I can understand your argument, but you may just find that because of there was no violation, there was no person's right of privacy. When Brandeis wrote his article, there were no fax machines. He couldn't have had in mind a person's, and the only question is whether, right now, you've got broad language in a policy that happens to encompass a new federal statute.
The only response, Your Honor, would be first, that it's not at all clear that this aspect of the statute was meant to deal with privacy. When this statute was enacted 16 years ago, the real concern, because faxes weren't as prevalent then, was telemarketing through direct phone calls.
Right.
That's where the privacy interest comes in. The concern with junk faxes was that it would shift the cost of advertising, that it would interfere with commerce. But this was not pleaded as a privacy case. Under this court's analysis in Boston Symphony, there could be coverage if the facts pleaded satisfy the statutory elements for invasion of privacy.
Right.
We submit that the analysis that this court adopted in Schlesinger clearly shows that the faxes were sent every 4 or 5 months. They're not repetitive. They didn't disrupt the daily routine. And these were listed phone numbers. It clearly doesn't satisfy the elements of the tort under Massachusetts law, and therefore coverage B shouldn't apply. Thank you.
Thank you, Mr. Aylward. We'll take a short break.